Welcome to The Point of Law. In May 2026, the Harbor Justice Center became the staging ground for a significant legal test. The Orange County District Attorney filed an amended criminal complaint against Tommi Jo Mejer following the death of an 81-year-old pedestrian. This case centers on the specific legal mechanism of holding a parent criminally responsible for the independent recreational actions of her 14-year-old son. District Attorney Todd Spitzer is pursuing a strategy of maximum prosecution to address what he describes as a profound failure of custodial care. The state's central thesis asserts that providing a high-performance electric motorcycle to an untrained minor is legally equivalent to handing them a loaded firearm. The prosecution's path to a conviction relies on deconstructing the statutory definitions of the vehicle, forensic evidence proving the mother's intent, and her post-collision actions. The Mejer represent an aggressive effort to expand the boundaries of parental criminal liability in American jurisprudence. The severity of the charges is a direct result of the life and death of Ed Ashman. Ashman was a retired United States Marine Corps captain who flew combat missions during the Vietnam War. At 81, he remained an active participant in his community, working as a substitute teacher at El Toro High School. On the afternoon of April 16, 2026, Ashman was walking home from the high school when struck by a 14-year-old riding an electric motorcycle. The collision occurred on the border of the high school campus, a geographical area where a heightened duty of care is legally expected, due to the heavy density of student and pedestrian traffic. Ashman was transported to a trauma center in critical condition and underwent major surgery. After a 2-week struggle for survival, he died from his injuries on April 30th. His death shifted the legal trajectory of the case, allowing the district attorney to upgrade the initial felony child endangerment charge to a prosecution for felony involuntary manslaughter. To establish the parent's negligence, the state first has to rigidly classify the machine involved in the collision under the California Vehicle Code. In California, a legal electric bicycle is limited to a 750-watt motor, a top speed of 28 miles per hour, and must be equipped with fully operable pedals. The vehicle operated by the 14-year-old was a 2025 Surron Ultra Bee. This machine utilizes fixed foot pegs rather than pedals and relies on an electric motor capable of 12,500 watts of peak power. This side-by-side comparison shows a legal Class 2 e-bike against the Surron Ultra Bee, which reaches a top speed of 58 miles per hour and can accelerate to 31 miles per hour in 2.3 seconds. As the data illustrates, the Surron produces 16 times the power legally permitted for a standard e-bike. Under California Vehicle Code Sections 400 and 405, these specifications remove the vehicle from the bicycle category and define it as a motor-driven cycle, or motorcycle. This classification triggers mandatory requirements for street operation, Department of Motor Vehicles registration, liability insurance, and an N1 or M2 motorcycle license. Furthermore, the operator of such a vehicle must be at least 16 years of age. By documenting these mechanical facts, the state establishes an objective statutory violation. Mejer facilitated an unlicensed 14-year-old operating an unregistered, uninsured motorcycle on public roads. Proving the mechanical violation is only half of the state's burden. To secure a manslaughter conviction, the prosecution must prove Mejer's state of mind, her mens rea. Prosecuting parents for the actions of their children is often difficult because it requires proof that the parent had actual knowledge of the lethal risks involved. The prosecution's theory of criminal negligence relies on a phone call Tommi Jo Mejer made to the Orange County Sheriff's Department in June 2025. Mejer called to complain that local residents were taking photographs of her then 13-year-old son riding the electric motorcycle and posting them on social media. During a 28-minute interaction recorded on body-worn cameras, Mejer admitted to deputies she purchased the vehicle, explicitly stating she knew her son operated it recklessly. In response, the deputies provided a recorded, unambiguous warning. They informed Mejer that the vehicle was illegal for her son to ride and detailed the inherent dangers it posed to the public. They warned her specifically that she could face criminal charges if she continued to allow him to operate the motorcycle. This digital record transforms the case.
It provides an objective record of foreseeability that is often missing in parental liability trials. Because she was formally warned and chose to continue the behavior, Mejer's actions move from simple negligence to a reckless, conscious disregard for human life.
We now return to the afternoon of April 16, 2026, at the intersection of Toledo Way and Ridge Route Drive. At the exact moment of impact, witnesses reported the 14-year-old was performing dangerous wheelies in the middle of the street. This maneuver lifts the front wheel off the pavement, which eliminates the operator's forward visibility and neutralizes the front braking system, where a motorcycle's primary stopping power is located. The juvenile failed to stop and render aid to Ashman, instead fleeing on the motorcycle. In the hours following the collision, investigating deputies interviewed Mejer at her residence. During that interview, Mejer allegedly provided false statements, claiming neither she nor her son owned or had access to a Surron electric motorcycle. This attempt to shield the juvenile from the consequences of a felony hit-and-run forms the basis for a charge of accessory after the fact under California Penal Code Section 32. This deception, when contrasted with the June 2025 footage, allows the prosecution to argue a consciousness of guilt and a continuous pattern of circumventing laws. These combined facts are synthesized into the amended criminal complaint filed on May 1. The first count is felony involuntary manslaughter, predicated on the theory that Mejer's criminal negligence was the direct proximate cause of Ed Ashman's death. Count 2 is for felony child endangerment. The state argues that by providing a 58-mile-per-hour motorcycle to a 14-year-old, Mejer willfully placed her own son in mortal danger. Count 3 is felony accessory after the fact, targeting the alleged attempt to conceal the vehicle from investigators after the crash. These are supported by misdemeanor counts for contributing to the delinquency of a minor and loaning a motor vehicle to an unlicensed driver. The final count is providing false information to a peace officer, specifically for the statements made during the hit-and-run investigation. If convicted on all counts, Tommi Jo Mejer faces a maximum sentence of 7 years and 8 months in state prison. The indictment demonstrates how a series of mechanical facts and personal choices are translated into a severe felony prosecution against a parent. The district attorney's office continues to employ the loaded weapon analogy, rhetorically framing these high-performance machines as inherently lethal in the hands of a minor. This case is a deliberate attempt by the Orange County District Attorney to establish a new legal precedent for parental accountability. It is a part of a widening crackdown. This is the third instance in 2026 where parents in Orange County have faced felony charges for allowing the illegal use of electric motorcycles. The legal battle moves to Department H1 at the Harbor Justice Center for Meisner's formal arraignment on May 21, 2026. The outcome will redefine the intersection of the Vehicle Code and the Penal Code, establishing how the justice system holds parents accountable for the lethal potential of high-performance electric vehicles operated in violation of the law.